Justify. Prove to be right or reasonable. Justification is at the heart of all legal and political argument. But at a time when argument itself is slave to appearances, it is time to bring back a culture of justification. Justify, a podcast on law and politics in India from the Vidhi Center for Legal Policy, hosted by Arghya Sengupta.
Welcome back to the second season of Justify. Thank you for tuning in again. With the pandemic, a lot of water has flown under the bridge. Many of us have lost some of our near and dear ones. May they rest in peace. And may all of us have the strength to see the pandemic through. After a very successful first season, a lot of you suggested that since this is a show that you listen to in the evenings, it can be slightly lighter, more accessible, and with less legalese. Also, that since it really isn't a current affairs show, and there are plenty of current affairs podcasts on law that have come up recently, we stick to our core strength, and that is an adda. When I was growing up in Calcutta in the late 80s and 90s, a staple to-do of weekend evenings for my parents was an adda. For the uninitiated, this was a conversation about all things ranging from the latest football match between East Bengal and Mohun Bagan to Foucault's Panopticon and everything in between. In between, there could be some music, some trivia, and lots of food and drink. The point wasn't to change things. It was to open one's mind to other points of view, to hear and be heard, and end the evening more human than one was when it began. This is what we hope to recreate on the show. Chat about contemporary issues on law and policy, intersperse it with some music, throw in some trivia with Clatter, our legal quiz that's a bit tougher than Clat, postponed or otherwise. And though we can't do food and drink on the show, our prizes this time will still be gift vouchers from Amazon, which is, after all, the everything store. Today's episode, the first one, is on free speech in India. Two judgments on prior restraints on free speech were handed down by the Supreme Court and the Andhra Pradesh High Court in September. The Supreme Court restrained Sudarshan News from telecasting future episodes of its program Bindas Bol. The channel was planning to continue a series called UPSC Jihad on how Muslims were planning to infiltrate India's civil services. The Supreme Court stopped future broadcasts of the episodes with an interim order. It also continued the hearing because it said it needed to foster a considered debate on setting up standards of self-regulation. The Andhra Pradesh High Court also passed an interim order restraining all media from publishing any information about an FIR which was registered against the former Advocate General of Andhra Pradesh and other accused persons relating to land purchases in Amravati before it was announced as the new capital of Andhra Pradesh. Both matters are now pending further hearing. This provides us with a great point of departure to discuss the question: is speech in India today actually free? To discuss this, I have two very special guests. Justice Chelameswar, former judge of the Supreme Court of India and part of the bench that delivered the judgment in Shreya Singhal's case, that widely credited with protecting free speech on the internet. I also have Tripurdaman Singh, author of a terrific book, 16 Stormy Days, on how the First Amendment to the Constitution of India, which among other things restricted free speech, came to be passed. Welcome, Justice Chelameswar and Tripurdaman. Thanks very much for being here.
Thank you.
Absolute pleasure.
So, Tripurdaman, I'll start with you and from your book. India's history of free speech is, of course, a very checkered one. And we often forget that it was the first government of Pandit Jawaharlal Nehru, which was actually the Constituent Assembly sitting as the provisional parliament, that allowed governments wide powers to restrict free speech. Of course, constitutional lawyers would know that as Article 19(2) of the Constitution. What, in your view, has been the historical attitude of governments in India towards free speech? And whether it's restrictions in form of bans, censorship, criminal cases, are they really a recent phenomenon?
I don't think they're a recent phenomena. I mean, the laws itself date back to the colonial period. So there's a historical trajectory to most of these legal instruments, especially all of the instruments in the Indian Penal Code. But I think the First Amendment is such a crucial turning point, and it is a crucial turning point because the Constituent Assembly had been very clear that as far as issues of sedition, for example, or Section 153A went, that these were not instruments that they wanted used in free India. And that is also the attitude that the judiciary took, and that is also what the press and civil society assumed. So I think, yes, there's a checkered history, but there are also bright spots, and it's very important to remember that there were those bright spots, and the judiciary has been, one of the big bright spots as far as that is concerned.
So before we get to the judiciary, if you could take us through the passage of the First Amendment through those 16 stormy days, in sort of maybe 16 non-stormy seconds, that would be great.
In a nutshell, basically, the government had faced a lot of embarrassment in its attempt to censor free speech. So there'd been a pre-censorship order against the organizer, and of course there'd been an outright ban on the left magazine, a sort of communist-leaning magazine called Crossroads, which had led to these two now very famous cases: Ramesh Thapar versus the state of Delhi. Ramesh Thapar versus the state of Madras, and Brij Bhushan versus the state of Delhi. And because in both these cases, the Supreme Court had taken quite a strident position as far as free speech was concerned, read Article 19 in quite an expansive fashion, the government eventually responded with all of these restrictions via the First Amendment. And it was incredibly controversial even then. It was opposed by figures across the political spectrum. And what is really interesting to note is how many voices from civil society, made a point of intervening in the public debate. And I think that's, again, something we would do well to remember.
Yeah, so the Justice Chelameswar, I'll take that to you. Attitude of the Supreme Court in Ramesh Thapar and Brij Bhushan in sort of widely expanding a wide, generous reading of Article 19(1)A, which of course led to the First Amendment. How far do you think that attitude continues or continued after the First Amendment came into being, which obviously authorized restrictions because of the security of state in the interests of public order, decency, morality? How do you think the Supreme Court reacted? Is it the same Supreme Court that gave Ramesh Thapar, or was it more deferential to state restrictions?
In more than one way, it is not the same Supreme Court, I suppose. For the reasons, the composition of the court keeps changing almost every 3-4 years. And the First Amendment to the text of the Constitution makes a huge difference to the court. Because ultimately, when the court is required to lay down the law, primarily it is bound by the text of the Constitution. The Constitution authorizes restrictions in certain areas, subject to the question that those restrictions are consistent with the authority conferred by the Constitution. Necessarily, the attitude of the court would be different, and it is seen in practice over a period of time.
That's right. But as Tripurdaman was mentioning, that there still, despite the fact that the Constitution now authorizes wider restrictions, which of course the court is duty bound to uphold, there are these bright spots. For example, Bennett Coleman, Sakal newspapers, as in our Indian Express, as in these are all sort of in some sense bright spots. Do you tend to concur with that, or do you have a different reading?
There are certainly bright spots. There is no difficulty, though I may not agree with the examples you have given. For example, talking about Bennett Coleman or something like that, all those judgments which dealt with the commercial aspect of the freedom of the press. Eventually, what is the freedom of the press that was upheld in some of these matters their right to secure an advertisement from the okay, it may be necessary. No, this is a corporate press, and its survival depends upon the financial stability. Now, to secure that financial stability, one major component is the state support by way of advertisements. And whenever those advertisements are denied to some newspaper, of course, on some occasions, the courts, high courts, and also the Supreme Court laid down the principle that. But point is, the commercial aspect of free speech is different from the free speech simpliciter. When it comes to the free speech simpliciter, I would ask you for better examples.
So is the point that you're making that when it comes to free speech simpliciter, which by that I perhaps interpret that as meaning individuals exercising their right to dissent, Share
singles case, yes. No, of course, it's a different matter that I happen to be a signatory to that judgment. Therefore, I don't want to talk much about that. But these are areas, they have nothing to do with the commerce.
That's right. No, but my question is the point that you're making that in cases which are dealing with free speech simpliciter, protest, dissent, fighting words, hate speech, are you saying that the Supreme Court perhaps has not been as liberal as it has been in cases?
I believe so. I'm not saying it is totally, but it is more liberal when it came to the commercial rights of free speech, the commercial rights associated with free speech.
Right. So, Tripurdaman, coming back to you, because you mentioned these bright spots, could you tell us a couple of bright spots that you had in mind in terms of the judicial history?
Cases like A.K. Gopalan, for example, or much later cases like Minerva Mills. I mean, cases through which even the sort of basic structure doctrine through Kesavanand Bharti, which has been admittedly my understanding of the legal process comes from because I'm not a qualified lawyer. I always see these things as a kind of method by which the Supreme Court has erected a dike, so to say, for fundamental rights. And as how strong it is, of course, is not for me to judge, but I still see it as a kind of bright spot because in India, there's almost a constant struggle against executive power, and it's like a war of attrition, if I might call it. So I think I would see all of these things as kind of bright spots.
Yeah, these are good examples in terms of the judiciary checking executive power. But I think what I'm taking away from this is that the judiciary chooses its cases carefully when it takes on executive power, and pure form cases of treason and sedition are perhaps not those cases, because obviously we've had cases where the law against sedition was upheld as a reasonable restriction on free speech, and we all know these cases that exist. And perhaps,
but, sorry, if I butt in, is that of course is a post First Amendment thing, because pre-First Amendment you had the Tara Singh case where the judiciary was as unambiguous as I could possibly expect in stating that this was unconstitutional. So as Justice Chelameswar pointed out, the court is, in a sense, I would say, bound by its constitutional obligations.
That's right. And of course, Kedarnath Singh versus the state of Bihar perhaps is one of the dark spots in that sense of India's free speech jurisprudence. And perhaps that's the reason, because I was just looking at some recent instances, perhaps that's the reason as to why we find that till this date, and perhaps increasingly so, the executive continues to use powers under the criminal law to incarcerate people for things they have said. So just a couple of examples that I put out. In 2019, Faham Azim Siddiqui was arrested by the police and charged with sedition for 5 years after posting a morphed photo of the Prime Minister. A few years before that, Ambikesh, who was a professor in Calcutta, was was charged similarly for making cartoons of the Chief Minister, Mamata Banerjee. The Chhattisgarh police booked a journalist, Kamal Shukla, under sedition charges for sharing an allegedly inflammatory post, the post which was a cartoon on the judiciary and politicians shared after the Supreme Court's judgment in Judge Loya's case. So it goes across party lines, it goes across institutions. And what we generally tend to see is that despite these bright spots which have existed, cases of this nature are commonplace. So, Justice Chelameswar, taking that to you, there have been bright spots on free speech. There have also been cases such as the ones that Tripurdaman spoke about, whether it be Keshwananda or Minerva Mills, where the judiciary in his language has erected dikes against the executive. But what explains this kind of enthusiasm of governments to keep filing criminal law cases against people who are merely expressing their point of view, even innocuously, like through a Facebook post?
But my own understanding is that it is the nature of the power. Generally, people in power won't like criticism. And I believe, I hope I'm wrong. As a society, we Indians are less tolerant to criticism, particularly if we happen to be in power. If you're out of power, of course, we have no choice but to be tolerant. If we are in power, whatever be the nature of the power, maybe it's executive power or judicial power or whatever is the nature of the power, the tolerance levels are slightly lower, according to me. Now, that's in my view. In fact, in one of my judgments, I quoted, I don't really remember which one of the judgments. There's an old anecdote. When Cromwell was the Lord Protector, some scurrilous material was circulated, some pamphlet kind of thing. So one of his friends brought it to his notice and suggested that action be taken in the matter. There's a famous statement, I'm sure you must have come across that. So Cromwell famously said, "If my government is here to stay, I have nothing to worry about a paper shot. Let him have the paper, I'll have my government." That perhaps is the most healthy attitude in these matters. But then, I don't know. I certainly didn't find this level of liberal minds in this country. There are of course, but then generally speaking, people get offended too fast.
That's right. And I think we've reached some ridiculous extents of taking offense, I think, over time. Sorry, you were saying something just still.
I think it's, first of all, it's in the nature of the power. Perhaps secondly, it is the social structure of this country that people in authority are less and less tolerant about criticism.
So, Tripurdaman, I know you're not a lawyer, but you're certainly a free speech historian. So, using your lens, do you think that that Indians have become more prickly about taking offense over time, or is this something that you think has existed always? Something from your research, perhaps, that could illuminate what's happening here? And just as an example, I'm an avid Bollywood watcher, and there was a spate of cases about a decade or so ago where people wanted all kinds of things changed in lyrics of Bollywood songs. As I remember, Gulzar had written a piece of lyrics in a film which uses the word teli ka tel. Okay, teli is a caste of people who work with oil. Mm-hmm. And there was a huge uproar. And if you hear the song now, there is this very odd expression called Dilli ka tel, okay, which makes no sense whatsoever, but because the Telis took offense. And similarly, there was a film called Billu Barber, which then became Billu, because apparently barbers took offense. So is this something that is a recent phenomenon, or is this something, as a historian, you think has gone on for Kingdom Come?
So one of the things that I noticed while doing research on my last project on the First Amendment was how angry politicians were getting with their portrayals in the media and with their. I mean, one of the big sort of lead-ins to the Brij Bhushan case was the fact that the organizer was publishing essentially cartoons of Jawaharlal Nehru and Liaquat Ali Khan, and with titles such as "Villains versus Fools," and this was really raising hackles. So I think there is, as Justice Chelameswar mentioned, I think there is actually something in Indian society. There's of course, liberalism of that sense has always tended to be a bit of an outlier, but also I think levels of social trust, or even like almost a sort of non-acceptance of humor is something that you can kind of see across the board, and it's almost as visible in 1950 as it is now in 2020.
Yeah, that's right. I think I'm reminded of what Albie Sachs, the South African Constitutional Court judge, had written in one of his judgments, and he started by saying that the law must always have a sense of humor. And I think that's something that not just the law, but I think anyone in public life seems to be lacking. But I think I'd like to move on to a second subject, which is very critical in this discussion of free speech, and that is hate speech. And hate speech is, of course, an area that is widely accepted as requiring some form of prohibition. And this is speech that incites violence. As in American constitutional parlance, it's called the fighting words doctrine. And India, of course, has criminal law that makes hate speech, that is speech that spreads hate towards a particular religion, caste, or community, an offense that can land someone in jail for 3 years. Justice Chelameswar, how do you see Section 153A of the IPC? Do you think, is it a reasonable restriction on free speech? Or on the other hand, do you think that it's good enough? Or do we need to do more to prevent hate speech?
No, I personally believe it's a reasonable restriction on free speech. Anything which is likely to disturb the peace of the society generally, it can't be consistent with the constitutional values of free speech or any one of those constitutionally guaranteed rights. But point is, how effectively that provision is enforced is a different question. I think we need a lot of research into it. How many times that provision was effectively invoked and enforced? It is there in the statute book. Now, quite a large number of cases, people get away with an objectionable speech which can fall within the framework of that prohibition. Now, what I believe is that we may not need any further statutory provisions, but an effective implementation of what is there.
That's right. But let me take the premise of your point, because I don't have the data in terms of the number of cases filed under 153A. I think that would be interesting to do. But if we take the premise where you said that, of course, anything that affects order in society, as it is a reasonable restriction, as it is of the wording of Article 19.2. But then let me take the example of the parallel in the First Amendment in the US, and the fact that burning the national flag is seen as also seen as an expression of free speech, as is cross burning, which is widely understood as demonstrating hostility towards African Americans. Now, these are definitely actions or speech that is causing some kind of lack of tranquility, particularly cross burning, which is directed towards a particular community. So, can we think about how we draw the line here? That do we say that all such cases are reasonable? Do we say that some cases are reasonable restrictions, but some are not? How do we draw this line?
See, the cultural values and the tolerance levels of societies vary. And for the same society, these things may vary from time to time. At a particular point of time, what is accepted as a tolerable speech might become, whip up violence at another point. It all depends on the system. So therefore, whether we should see, for example, after the Jehovah's Witnesses case in US, Now, the Indian Supreme Court, if you recollect that judgment of Justice Reddy, what is it,
Joe Emmanuel.
Vijay Emmanuel's case, where just the Supreme Court invoked that Jehovah's Witnesses judgment of the Supreme Court. By and large, of course, Reddy was very bitterly criticized in certain quarters for the judgment. It's part of the any judge. So long as the criticism is academic, there shouldn't be any difficulty. We should welcome it, actually. But virtually it became a personal attack, questioning his nationalistic credentials. So that's where the trouble starts. Now, you may say that his judgment is not consistent with the constitutional values as interpreted by the court from time to time. It's a different matter. One may say it, one may agree with, one may not agree with. But merely because, and what did he do? He imported a principle which was initiated by the Honorable Supreme Court. And the minute that is done, you start questioning his nationalistic credentials. Now, it is certainly not a tolerance. You are crossing the line. So these are the areas which create trouble.
That's right. And I think, as just for our listeners who may not have come across this judgment, this was judgment relating to Jehovah's Witnesses and their standing up for the national anthem in India, and whether they had it was part of their freedom of religion not to stand up for the national anthem and pray to anyone except Jehovah. And Justice Chinappa Reddy had upheld that right. In that case, I wonder as in how that would have been seen even today. But as you made very clear, it was not taken to very kindly at that time as well.
Only some segment of people, not most of the people simply didn't bother either way.
Yeah, no, I was just thinking that, in the age of social media, perhaps this would have been blown out of proportion significantly. Now, coming to the world of social media that we live in, because that obviously seems to make a difference to the way in which both freedoms and duties are exercised, because everybody has a microphone now. And everyone's voice
smartphone, not microphone.
A smartphone. Seems like. Yeah, everyone has a smartphone, which is like a microphone, which makes everyone's voice audible to the rest of the world.
You can reach the whole world.
Yeah, as in so much more than a microphone. Maybe my analogies have to keep up with the times. But I'll circle back to where we started with this Bindas Bowl show, and we can play a clip for folks to try and understand what this was about. But very simply, what the show was about, and I had written in the aftermath of it, that the single point focus of the program, as broadcasted, appears to be to create a frenzy of fear based on the perception that Muslims by design are attempting to take over the civil services in India and that state authorities are complicit in this exercise.
सरकारी नौकरशाही में मुसलमानों के घुसपैठ पर बड़ा खुलासा। आखिर अचानक मुसलमान आईपीएस आईएएस में कैसे बढ़ गए? सबसे कठिन परीक्षा में सबसे ज्यादा मार्क्स और सबसे ज्यादा संख्या में पास होने का क्या है राज? सोचिए, जामिया के जिहादी अगर आपके जिलाधिकारी और हर मंत्रालय में सचिव होंगे तो क्या होगा? लोकतंत्र के सबसे महत्वपूर्ण स्तंभ कार्यपालिका पर कब्जे का पर्दाफाश। देखिए, नौकरशाही जिहाद पर हमारा महाअभियान शुक्रवार 28 अगस्त रात 8 बजे से बिंदास बोल में मेरे साथ।
So Tripurdaman, as a person outside the legal fraternity, especially given the fact that you have more roots in common sense than perhaps we do you think that there are any complex constitutional questions that this case raises, or do you think it's a case of hate speech simplicity?
2 points, just as I kind of go into it. One is, I mean, conspiracy theories such as these, and my first reaction when I heard about this case and I saw that clip was that these sorts of conspiracy theories, again, are something that throughout the world have been very, very common. And even now, I mean, there are people who believe that, Hitler escaped Argentina, or they're like, there's a Nazi plot to take over the world that is still being hatched somewhere out in the wilds in Patagonia. And so there are, I mean, these sorts of theories keep coming up. But I think as far as hate speech goes, it obviously, as you pointed out in the article, there seems to be only one objective, and that is to demonize a particular community. And I think the legal arsenal that the government has and the sort of principles that the judiciary has delineated have provided enough ammunition to deal with an issue like that. I don't think it opens up a constitutional question again. I would have thought that as something that has already been settled.
Justice Chelameswar, do you tend to agree with that without going into the facts of this case in too much detail?
I broadly agree with him. Actually, in my view, it was a case where the authorities could have simply invoked that Section 153 or whatever is of Indian PAN numbers. I'm not very still. They could have simply invoked it, or anybody could have invoked that and lodged a complaint. It was not really a constitutional issue. It is a question within the framework of the existing law.
That's right. But anyway, it has given us an opportunity, as in perhaps under the aegis of the Supreme Court, to try and see where this balance between 19(1)(a) and 19(2) that was originally thought to be changed by the First Amendment lies today.
See, there I say something. Just as a smartphone, we were talking about a few minutes back, this 32 and 226 jurisdiction over a period of time is slowly trying to short circuit the regular established procedure of law. It is both the civil and criminal laws. Now, people simply rush to the constitution courts for these problems. Now, there can be many reasons for it. Maybe the regular legal process is painfully slow or ineffective. Therefore, maybe it requires a great deal of analysis why it is happening. But the minute you reach the constitutional court, necessarily the projection is there is a constitutional issue. If somebody were to file a simple criminal case in that matter, now, unless the accused decides to challenge that criminal proceeding as being opposed to his fundamental rights guaranteed under freedom of speech and so on and so forth, there is no constitutional issue there. Simply a criminal case, whether you answer the charge, either you are found guilty or not guilty, that is the end of the story. The minute you rush to the Supreme Court or the High Court for that matter, and any matter, not only this, every matter, then issues become constitutional. That's what.
I think that's a great point, because Tripurdaman, would you like to comment there?
No, I was merely agreeing with Justice Chelameswar. That is a great point, and I think people do have a tendency to kind of because the sort of record of the lower judiciary is so patchy that there is the tendency to kind of leapfrog the regular channels. And the other issue that I actually wanted to say is that yes, the laws are all there, and the problem is that there seems to be no consistency of application of who gets convicted or who gets charged. And in the absence of that sort of consistency of application, it's quite hard for the judiciary really, or the state generally, to be honest, to be able to lay down any sort of normative principles, to have first principles that we know will be applied relatively consistently through space and time. And I think that's a question that still has to be addressed.
No, that's right. And I think what I'm taking away from this is the fact that we've got what seems to be in India now a society that's tending towards illiberalism, and we've got a state across political parties that's more prickly than perhaps ever before. But states have always been prickly, and we've got a judiciary that is choosing cases selectively because people are making issues that are sort of simple issues within the framework of criminal law, weighty constitutional issues. So the courts are weighing in on some cases and perhaps not on others. So last word to both of you: how do we see this evolving? If you were to just speculate about liberalism in India going forward, and what the future holds for free speech. What do you think, Justice Chelameswar? Where are we headed? Are we heading towards more restrictions and self-censorship, or are we heading towards a world of social media where speech is truly free and perhaps sometimes irresponsible?
Both. When you talk about free speech as understood earlier in terms of the print media, and at a later point of time the TV, after the advent of private enterprise in the TV business. Now, certainly there are restrictions, and it's possible to handle them or mishandle them by the state. But the minute you have this internet and you have the smartphones, and I understand there are some 20 crores of smartphones in this country right now in use, and the numbers are going to increase. Now, free speech, even to the extent of being very unreasonable, as Winston Churchill puts it, where there is a great deal of free speech, there is bound to be a certain amount of foolish speech. Perhaps there's a great number of mobile phones available, smartphones available. There is bound to be a great deal of foolish speech in this area also. Okay.
Right.
So, therefore, really, in that sense, it's not the question of law. It is really the technology which is going to decide these questions in future. The authority of this, as we have seen, if you recollect the events of 1990, when around the time the Berlin Wall was torn down. Now, one factor, of course, it is an analysis I read somewhere, one factor which really helped this process was the possibility of receiving the television programs from the western side of the wall, because that could not be stopped. People crossing over the wall could be stopped, they could be shot down. But then there's no way the television waves could be stopped by any government, East German government or Soviet government. So therefore, the technology is going to create the freedom. And whether people are going to use it wisely or unwisely is a different story. The tendency appears to be the freedom is likely to be abused.
That's right. Tripurdaman, I know you're a historian who prefers looking at the past, but if you were to look at the future?
I think I'd agree with Justice Chelameswar. There's with fast-changing technology, the birth of artificial intelligence, the appearance of deep fakes, there's going to be such a surfeit of information and so little trust as to which information is verifiable or not, what is the truth or what is not the truth, that it's going to become impossible really to have these sorts of restrictions in any sort of meaningful sense. But what people, again, I'm a bit more optimistic. I think there is a kind of, I think there, with the growth of adequate social trust, I think that these effects can be mitigated to a certain extent. As far as India is concerned, I'm just going to take 1 second to quote Sunil Khilnani from my book, who described Indian liberalism as crippled from its origins, stamped by utilitarianism, and squeezed into a culture that had little room for the individual. And to change that, I think, is a much more difficult proposition. I think that's a profound social question.
That's right, and I think that's also a question, the point of which we can leave. But yes, last word to Justice Chelameswar.
Oh, sorry, I just wanted
last word is always to the judge.
Well, I'm a retired judge. No, I don't know. I'm sure you must have read that book, Noah Harari's recent book, 21 Lessons for the 21st Century. Did you?
Mm-hmm.
Did you? Anyway,
I haven't read it, but yeah.
Please read it. It's a very, very good thing. Like he says about the fake news, there are certain pieces in that book. He gives a particular instance. Sometime in 1255, a young boy was killed in a town called Lincoln in UK, allegedly by the local Jewish population in some ritualistic sacrifice kind of. That is the belief. And then some 21 Jews were tried and executed. And of course, Harari very, I don't know whether humorously or cynically says, even in the absence of internet and Facebook, the news spread very fast across Europe. And then it became a pattern. And for a long time, for 500, 600 years, or 700 years, it was believed that Jews were responsible. Eventually, the church ultimately issued a statement saying that it was fake information. And Harari concludes that particular article saying, some fake news lasts only 700 years, he says. So the possibility of fake news with artificial intelligence and all the modern technology, it's a very tantalizing prospect.
Absolutely. But it also shows...
And human beings are, at least have not exhibited any great intelligence in the history not to abuse the technology.
Mm-hmm. That's right. And I think that's what it shows, that, technology is always a medium. It exhibits either our best or our worst, and depending on what we want to demonstrate. And I think we've had a terrific conversation, and I thank everyone for listening in, and particular thanks to Justice Chelameswar and Tripurdaman for joining me today. And the history of free speech in India is a checkered one, so we have to see how it evolves. But we have been in difficult times, but as Tripurdaman says, there are bright spots, and we must cling on to them. Thank you very much. Thank you. For the listeners, the episode isn't over yet. Today's clatter question remains. So write in with your answers to justify@vidhilegalpolicy.in. Here's our question for this week. In a 1906 book, the author, who wrote under a pseudonym, composed a sentence that has become synonymous with the freedom of speech. The sentence is often misattributed to another author who features in the title of this book that was written in 1906. What is the sentence that has become synonymous with free speech, and what is the title of this 1906 book? Write in with your answers to justify@vidhilegalpolicy.in. Right answers stand a chance to get a very special Amazon voucher. Thank you once again for joining the show. But before you go, remember, speech is always free if we want it to be. The poet Fairs says it best. Listen to the song. Take care and stay healthy. Adjourned.
बोल के लब आजाद है तेरे, बोल जुबान अब तक तेरी है, तेरा सुतवा जिस्म है तेरा, बोल के जब तक तेरी है, बोल.
If you enjoyed listening to this podcast, follow us on Twitter @Vidhi_India for regular updates. We are on SoundCloud and Spotify as Vidhi Center for Legal Policies podcast. You can also listen to us on Google Podcasts or iTunes. Email us at justify@vidhilegalpolicy.in to share your comments and feedback on this episode.